Hello, so we've got another kind of short video to do now. This is we're going to go through Lively's opposition to Wayfarer's motion, limine number 5, which is to preclude evidence and argument relating to pretrial filings and the court's ruling. Okay, so defendants seek to preclude all reference to Lively's motions for sanction, as well as to the court's rulings on such motions, and to exclude any evidence, argument, or suggestions relating to the dismissed Wayfarer complaint. That motion should be denied to the extent that it seeks to preclude evidence and argument relating to defendants' dismissed action against Lively and Reynolds, for which the court imposed sanctions under Rule 11. The motion should also be denied to the extent that it seeks to prevent the jury from hearing about defendant's spoliation of evidence, because permitting such argument may be among the remedies for such spoliation. Now, Judge Lyman hasn't actually ruled in favour for Lively here, so on the spoliation of evidence sanctions motion. So I'm hoping he kind of, he needs to deal with that quite quickly, ideally before the trial. But yeah, I mean, he hasn't. She's saying this as if it's a given, and actually, it's not. And I did not find her the motion she actually filed for the spoliation sanctions to be particularly strong or convincing. Okay. First, contrary to defendants' broad claims about the irrelevance and prejudicial nature of evidence relating to a court's previous decisions in the case, including sanctions motions, in the circumstances of this case, defendants' dismissed action and the court's Rule 11 determination is directly relevant to Lively's retaliation claims and not unfairly prejudicial. I mean, when Lyman awarded the Rule 11 sanctions, it wasn't for Friedman's statements, which is what she was really going for. It was just because of the group pleadings. Like, it was nothing to do with the retaliation. It's just that Wayfarer hadn't written their complaint. They filed the complaint and they basically improperly group pled some of the causes of action. So you had Melissa Nathan and Jen Abel were, on paper claiming for a breach of contracts that they did not have with Lively and Reynolds. So yeah, it wasn't a good filing from that perspective. It was sloppiness. But she's kind of saying, well, the judge agreed with me that it was part of the retaliation, so it should be evidence. That's not what the judge said at all. In fact, he expressly stated that Friedman was entitled to defend his clients, and there was no retaliation. It was for no other reason than, the layout of the complaint. I think it's prejudicial. Specifically, Lively is entitled to introduce evidence that Ainsworth's movie brought an objectively baseless action against her and argue that this was a retaliatory adverse action. I wouldn't argue that it was objectively baseless because, Wayfarer had less claims thrown out than Lively did in the end, but the judge actually gave leave to amend 4 of those complaints, 4 of those causes of action. They chose not to. So the fact that they were, there was wiggle room for Wayfarer to go away and amend its complaint to bring back 4 causes of action against both Lively and Reynolds actually does not suggest that the entire complaint was baseless. I think people keep forgetting that. As this court has recognised under California law, retaliation claims are inherently fact-specific, and the impact of an employer's action in a particular case must be evaluated in context, considering the unique circumstances of the affected employee as well as the workplace context of the claim. And the court has further recognised that one of the defendant's core defences in this case is their assertion that even if they contemplated taking offensive action against Lively, they never ended up doing so. It ends with us movies filing of an objectively baseless claim against Lively for which it was sanctioned under Rule 11. It was not sanctioned for that at all. Wow. It was not sanctioned for that. Constitutes a retaliatory adverse action and thus bears directly on an element of Lively's statutory and contract claims. It also disproves defendants' self-serving narrative that they never followed through on their intentions to retaliate against her. Separately, and combined with the jury's conclusion that defendants' and other third-party witnesses' testimony on that subject is not credible, would support a verdict in Lively's favour. As is well established, retaliatory conduct can include retaliatory litigation, and while courts have held that an employer who is facing a lawsuit filed by its employee charging discrimination can file a counterclaim without committing an adverse action within the meaning of the anti-discrimination statutes, so long as the counterclaim is filed without a retaliatory motive and with a reasonable basis in fact or law. The flip side is also true. Courts have held that baseless claims or lawsuits designed to deter claimants from seeking legal redress constitute impermissibly adverse retaliatory actions. Let's just remember the timeline of events. Wayfarer actually filed a lawsuit against New York Times, not Lively. Lively filed the lawsuit first, and then Wayfarer filed the lawsuit after. Defendant's dismissed complaint is thus of questionable relevance to Lively's claims. So is the court's ruling under Rule 11, which confirmed beyond doubt that Ainsworth's movie filed that action without an objectively reasonable basis to do so. Specifically, the court held that Ainsworth's movie simply had no basis to sue Lively or Reynolds for civil extortion, and did not identify even an arguable basis in law or fact for Ainsworth's movie to assert a tortious interference claim against them. Moreover, as the court recognised, these objectively baseless claims were not harmless, including on the grounds that other plaintiffs who brought those claims did not face sanctions. A claim by a person that the defendant has committed a tort or breached a contractual relationship is not to be made lightly. It can carry reputational consequences even if that same claim is properly made by another party. Ainsworth's movie's conduct in filing the lawsuit and the court's conclusions about its reasonableness are unquestionably relevant to Lively's claims. I don't agree with that. Lively should be allowed to present evidence to the jury that Ainsworth's movie filed a lawsuit against her that the court determined to be objectively baseless, and to ask the jury to conclude based on that and other evidence that Ainsworth's movie's true motive for filing that action was retaliation for her opposing conduct during the production of the film, including by filing the CRD complaint in California. Moreover, no cognizable prejudice, much less unfair prejudice, would result. Defendants do not explain how introduction of this particular evidence would be prejudicial, only asserting in conclusory fashion that it is so. Not only would the relevance of this evidence not be substantially outweighed by the danger of unfair prejudice, it would be unfair to Lively to exclude this evidence. Any prejudice would reflect not unfairness but the accuracy of Lively's contention that Ainsworth's movie engaged in actionable retaliatory conduct against her. It would be unfair to Lively to exclude such evidence because she filed a motion seeking to establish that Ainsworth's movie's claims were objectively baseless, and then the court agreed with that position. To be clear, in light of the court's ruling, it's hard to imagine that a reasonable jury would disagree that Ainsworth's movie's claims lacked an objectively reasonable basis in law or fact, or that it was a reasonable defensive measure. But at a minimum, no unfair prejudice would result from the jury hearing evidence relating to that lawsuit and the court's Rule 11 decision, much less any unfair prejudice that would substantially outweigh that evidence's probative value. Defendants' Rule 401, 402, 403 arguments must be rejected. Similarly, defendant's Rule 404 argument must be rejected as to this evidence because it would not be offered to prove that, on a particular occasion, any party acted in accordance with any character or trait. To the contrary, Lively seeks to introduce this evidence in order to establish that Entworth's movie engaged in a particular conduct, because that conduct, if proved, would establish an element of her claims. The fact that Entworth's movie filed a lawsuit against Lively that was found to be objectively baseless simply is not character evidence then when offered to prove that Entworth's movie committed a retaliatory adverse action against Lively by filing that lawsuit. Defendant's 404 argument must be rejected. A similar analysis applies to evidence relating to defendant's spoliation of evidence, as even defendant's own case recognizes at a minimum the jury must hear whatever adverse inference or similar instruction results from Lively's spoliation motion. As Lively explained in that motion, the potential remedies for defendant's conduct may include mandatory presumptions regarding the lost information or permissive or mandatory adverse inference instructions to be delivered to the jury. And in the alternative, and at a minimum, Lively should be permitted to present evidence and argument to the jury regarding the lost documents and to seek further curative instructions. To the extent Lively's spoliation motion is granted in any relevant part, not only must evidence of that ruling not be excluded, whatever remedy she receives must be presented to the jury. Finally, defendants seek to exclude any reference to court proceedings involving pretrial publicity and sealing. While it is difficult to understand what evidence defendants may be referring to the extent this request seeks to prevent Lively from introducing evidence of the damages she suffered as a result of defendant's retaliatory litigation, it must be rejected. That evidence includes evidence of various publicity stunts, statements, and a digital campaign defendants and their agents engaged in order to make hay out of their retaliatory lawsuit and maximize its harmful effect on Lively. Independent of whether that conduct itself is itself actionable, such as Brian Friedman's retaliatory statements made on behalf of his clients, which the judge said was not retaliation. That conduct is indisputably relevant to the damages Lively suffered as a result of the retaliatory lawsuit, because it was one of the mechanisms by which that damage was inflicted. As the court recognized in granting Lively's Rule 11 motion, a claim by a person that the defendant has committed a tort or breached a contractual relationship is not to be made lightly. It can carry reputational consequences, even if that same claim is properly made by another party. Defendants sought to inflict just such reputational consequences by drumming up coverage of their $400 million lawsuit, and Lively is entitled to present that argument to the jury. As one of defendants' own cases recognizes, even evidence there relating to plaintiffs' dismissed claims that must be excluded on relevance grounds as to liability may be admitted for the purpose of proving damages. And any potential prejudice to defendants would be easily cured by an instruction making clear to the jury that they can consider such evidence only as it relates to damages. Okay, interesting. I don't know how Lyman will treat that. I think it's prejudicial myself. I don't think it's relevant, and she is completely mischaracterizing that Rule 11 sanctions decision by Lyman. And he hasn't even ruled on the spoliation sanctions motion, so I think he needs to kind of, pull his finger out and get on with making a decision there, because it is relevant. It's going to be pertinent to who can argue what. It's going to be pertinent as to jury instructions, because if he grants the spoliation sanctions motion, then Lively should be entitled to make that clear, and may well get some kind of jury instruction out of it. So that's kind of what happened with the Depp Heard trial, where Amber Heard, what was it? There was evidence of her photos of all her bruises being manipulated, or the metadata was off. I can't remember exactly what it was, but that formed part of a motion in limine. And it was they weren't allowed to talk about it. And when it did actually get into trial, and you saw that man kind of put those two photos side by side and place a filter over them, or point out that the same photo had been used as evidence in multiple incidents months apart, they had to tread very carefully and lay a kind of a foundation. And I think the door had to be opened as well by Amber Heard herself for that information to be used as rebuttal. I can't remember it all off the top of my head, but I know there was definitely something like sanctions were awarded because Amber Heard either hadn't provided evidence, or had she couldn't provide the metadata to go with it. Something was going on. I'd have to go back and look at it, but yeah, it will be relevant to Lively. So Judge Lyman really does need to kind of get on and just make a decision on the spoliation sanctions. I do think that he should slap down Lively and start sort of telling her, no, you're mischaracterized, because he didn't award the Rule 11 sanctions because of Friedman's statements, and he did not award them because the claims were baseless. Particularly, it was like improper group pleadings. So that's what that is about. And yes, that was fair, to be honest. That was exactly what happened. But Lively is trying to make fetch happen really here. So yeah. So the next video is going to be motion limine number 6, and that is to preclude references to other lawsuits, including involving defendants, the dismissed defendants, or their counsel. So we know this is going to be probably Travis Flores, Celeste Smith, Shane Norman, etc. There's going to be the stuff involving Melissa Nathan with Rebel Wilson and Amanda Ghost. I mean, it would be useful if Wayfarer intend to bring in the lawsuits against Lively and or Reynolds or the various entities for copyright infringement, stealing ideas, etc., such as the Starkloff lawsuit, Aviation Gin. We've currently obviously got, at the moment, we've got the choreographer who created and holds the copyright for the dance to NSYNC's Bye Bye Bye, which was used at the opening credits for Deadpool. He is now suing Disney, Marvel, etc., etc. He's not suing Ryan Reynolds, I will say that, but he is suing Sony. And there is enough evidence actually available that Blake Lively actually suggested NSYNC. She takes credit for that in her Instagram post. So you can definitely there is evidence where if Discovery could throw up, Ryan Reynolds and Blake Lively's involvement in that. They had the rights to the song, but the dance itself is a separate thing. So, and someone, a choreographer, can hold intellectual property on the dance sequence, and that was a very well-known dance sequence. And Nick Pauli, the dancer who dressed in the Deadpool outfit and did that dance in Deadpool, did it, move for move. It was identical. It was not like, any kind of improvisation of the original dance. It was the original dance. So you know, I would be, I mean, because Wayfarer, part of their defense is going to be she stole the movie. So I think realistically, I'm sure it'd be a challenge to get it in, and it'd have to lay a proper foundation for it. But they could, in theory, sort of argue, well, hold on, they got a history of stealing things. You know, they've been sued a few times themselves for that. Okay. Yeah, I'll be back with the video on motion limine number 6.